What is mediation? Unless you have been a party to a mediation or an advisor, you probably don't know what it involves. In a nutshell, it's a flexible and voluntary process where a neutral, qualified mediator assists parties in dispute to reach a settlement. The Mediation Act 2017 in Ireland obliges solicitors advising clients prior to commencing civil proceedings to consider using mediation as an alternative means of resolving a dispute. In Northern Ireland and in other jurisdictions where there is no legal requirement to give this type of advice, it is nonetheless increasingly considered best practice to do so. Why mediate? Let me share something with you. As a young lawyer, I was heavily involved in litigation, and I remember on one occasion speaking with a very experienced colleague. I told him about all the various interesting cases that I was involved in, and he said to me, "Brian, litigation represents failure." He went on to say that it represents failure by the parties to resolve the dispute themselves, but worse still, it represents failure by the lawyers to resolve the dispute on behalf of their clients. That view was well ahead of its time, and it sparked my interest in alternative dispute resolution, and more particularly mediation. So what are the advantages of mediation over litigation? It's fast. Mediations are routinely arranged and completed in a matter of weeks, as opposed to the years that it can often take to litigate a dispute. Litigation has become procedurally complex and time-consuming, involving lengthy pleadings, discovery of documents, interim applications, and so forth. And time costs money. If mediation is successful, it is considerably cheaper than litigation. Confidentiality. A mediation is confidential. The court process and the ultimate hearing is in a very public forum and can result in very significant reputational damage. Flexibility. Mediated settlements can involve flexible and imaginative solutions not possible within the parameters of litigation. I feel that the three most important features of mediation are: firstly, its speed; secondly, it's confidential; and thirdly, the flexible solutions that it offers. The mediator does not tell the parties how to settle the matter. It is a matter for the parties to reach a mutual settlement between them. The mediator simply assists the process. An important role that the mediator has is to give the parties advice if he feels that they're on the wrong track, and try and steer them back on course towards a possible settlement. But ultimately it is a matter for the parties to reach a settlement themselves.